warahmatullahi wabarakatuh to the lecturers and also my friends. So this is our group members, which is me, which is Hanisa Najwa binti Abdul Rasid, Nur Afifah binti Muhammad Asadullah, Mio Shakir Zufairi Al-Faruq bin Muhammad Jamal, Adam Wazif bin Awira, Wan Nuraina binti Muhammad Wan Muhammad Rozihas, and Nur Sharafina binti Muhammad Asri.
My name is Nor Afifah, and these are the main subtopics for Law of Agency Principle. The first one is agency relationship. The second one is duty of principle to an agent. The third one is types of authority. And the fourth one is types of principle. Agency. Agency is a legal term of art that refers to the relationship between principal and an agent. Creating an agency relationship. An agency relationship is a fiduciary relationship where one person, principals, allow an agent to act on her behalf. Example of agency is employee and employer, lawyer and client, and corporation and officer. Who can be a principal? Under Section 136 Contract Act, any person who is 18 years old and above and who is of sound mind may be a principal. Types of authority. The first one is actual authority and the second one is apparent authority.
My name is Hanis Najwa, so I will continue the presentation. So actual authority exists when the agent take an action on behalf of the principal and he reasonably believes that the principal wants the action to be taken. So you can see the picture here below, which is the principal belief that the agent want the action to be taken, which is to buy. So the principal must buy what the agent want. Next. So actual authority includes the express authority, which is means where the principal tells the agent exactly what to do. So from the picture below, you can see that the agent take action exactly as the principal asked to do, which is ABC. So the principal do also ABC. So next. So it also includes the applied authority, means where the agent takes action reasonably necessary to accomplish the objective of the agency. So as you can see, the agent act some other actions to do to ensure the objective is accomplished, which is what principal ask is ABC, but what agent do is ABC plus DE. So plus DE, which is a action reasonably necessary to accomplish the objective. Next. So a principal also can limit agents' authorities or revoke them as they choose. So as example, a principal who initially tasks an agent with purchasing a piece of real property may amend the instruction to limit the agent's authority to leasing the property instead. So from the picture, at first, the principal asks the agent to buy, but then at the last, the principal limit the agent authorities and revoke them to leasing the property instead. Next. Apparent authority. Apparent authority is when the agent take actions for the principal with the third party that the third party reasonably believe the agent has the authority to take. Next. Okay, apparent authority. This is the example, which is we can say that number one, which is a principal hire an agent to buy a good from any supplier with the budget less than 100,000 ringgit. And then, but the principal told the told the vendor that agent has unlimited budget. The agent has unlimited budget, but then the agent has apparent authority to buy more than 100K because the vendor reasonably believe that the based on the principal conduct, which is the action that principal done, is not wrong. Thanks. Thank you.
Hi, my name is Adawazil Awira. I will explain about the duties of principal to agent. Right. So for in section 175, agent to be indemnified against consequence of lawful acts. So the employer of an agent is bound to indemnify him against the consequence of all lawful acts done by the agent in the exercise of authority conferred upon him. So for the example, Mr. A asked Mr. B to buy goods from third party. Mr. B used his own money to buy instead. Mr. A must indemnify or pay back his agent money. Right? So in section 176, agent to be indemnified against consequence of acts done in good faith, whereon one person employs another to do an act and the agent does the act in good faith. The employer is liable to indemnify the agent against the consequence of that act. So it caused an injury to the right of the person. Right. So for the example, Mr. A asked Mr. B to do delivery of documents to third party. Mr. B, who in good health, go to do the job. Mr. B involved in traffic accident while doing the job and injured. Mr. A must indemnify the injury for Mr. B. Next. This is I pass to Mio.
My name is Mio Shaki Zufairi. Section 177, 9, liability of employer of agent to do criminal act. Contract Act 1950, where one person employs another to do an act which is criminal, the employer is not liable to the agent, either upon an express or implied promise to indemnify him against the act. Example, when Mr. B is employed from other person to do criminal act, Mr. A are not liable or responsible for the act. Section 178, compensation to agent for injury caused by principal's negligence. The principal must make compensation to his agent in respect of injury one caused to an agent by the principal's neglect. Example, Mr. A asks Mr. B to visit third party by car even though he knows that Mr. B doesn't have driving license. During the journey, Mr. B is involved in a car accident. Mr. A must indemnify him because of his own negligence. Thank you.
My name is Wan Reina. I will explain the types of principal. Principal are categorized based whether their identity is disclosed to the third parties with whom the agent interacts on their behalf. There are three types of principal, which is disclosed principal, partially disclosed principal, and undisclosed principal. Disclosed principal. A disclosed principal's identity is known to third parties dealing with the agent. The agent cannot be held personally liable for any damages resulting from the breach because in the event the contract is breached by the in legal situation, the court will try focuses on protecting the third parts who are handling the assets of principal. Example, I go in and say I am representing my client, Miss A, on her behalf. Okay, thank you.
Assalamualaikum, my name is Nur Shafina, and I will start presenting. The second part of principle is partially disclosed principle. A partially disclosed principle is known by third parties to exist, but her exact identity is unknown. This type of relationship exists when there is some benefit to the principal to remain anonymous to third parties interacting with the agents. For example, an agent represents a principal for big companies such as Disney and buying piece of land for a new amusement park. The seller did not know the exact identity of principal because the price would be increased rapidly if he knows who it is. Second slide. Um, the third is The third principle is undisclosed principle. The existence of undisclosed principle is unknown to a third party. The third party believes that she is interacting only with agents. These categorizations of principle are important in determining the rights and duties of principal, agents, and third parties. For notices, if in fact the agent was authorized to act on behalf of undisclosed principal, then the principal will also be liable on the contract and subject to indemnification. For example, here I go in and I don't say a word that I am representing someone else. Okay, yes, thank you for listening. Thank you.